All right, welcome. Today we're diving into a topic that sounds super complex, but it's actually vital for the world we live in: private international law. Now, this isn't about big treaties between countries. Nope, this is about you. It's about what happens when your personal life, your marriage, your business deals, your property crosses a border. And really, it all boils down to three big questions. First, which country's court gets to hear a case? Second, which country's laws should that court actually use? And third, if a court in one country makes a decision, will another country even recognize it?
Okay, let's jump right in with a real-world puzzle. You've got an Egyptian wife and an Italian husband. They're living in Italy, and for our story, let's say divorce is not an option there. So what does she do? She goes back home to Egypt and files for divorce. And boom, just like that, you've got a legal tangle. You have two different countries, two different legal systems, and a whole lot of questions. This is exactly where private international law steps in.
So this situation, it's not just about a messy breakup, right? From a legal point of view, it forces any court that gets this case to hit the pause button. Before they can even think about who's right or wrong, they have to answer two absolutely fundamental questions.
And this, right here, is the absolute cornerstone of this entire field. You might be thinking, well, that's easy. The court that hears the case just uses its own laws. But that's where it gets interesting. In private international law, those are two totally separate questions. Figuring out which court and which law is the first, most critical step, and remembering that they are separate is the key to understanding everything.
Getting a handle on this distinction, this principle of separation, is what unlocks this whole topic. You have to separate the idea of who gets to decide, the court, from the rules they use to make that decision, the law. It's this separation that allows the system to work logically and fairly when things get complicated across borders.
So here are the official terms. On one side, you have judicial jurisdiction. The easiest way to think about this is the where. It's all about figuring out which country's courthouse is the right one to even hear the case. On the other side, you've got legislative jurisdiction, which you'll also hear called conflict of laws. This is the what. Once you're in the right courthouse, what's the right rulebook? Are we using Egyptian law, Italian law? It's all about finding the right set of rules. I know, this sounds totally backwards, right? But this quote nails it. A court in one country might have the full authority to hear a case, but then be legally required to apply the laws of a completely different country. You could literally have a judge in Cairo flipping through Italian family law books to decide a case. This principle is the engine that makes the whole system work.
All right, so let's get back to our couple. We have to tackle that first question: judicial jurisdiction. Can the Egyptian court even take this case? Well, we can't just guess. We have to go to the source. We need to look at the specific rules written down in Egyptian law that say when its courts can or can't get involved. So let's check out the rulebook in Egypt. The Code of Civil Procedure there lays out some pretty clear guidelines. And what's really interesting is that they focus almost entirely on one person in the lawsuit, and it's not the one who filed it. That person is the defendant. In our story, that's the Italian husband. The Egyptian legal system looks at the defendant's status to decide if its courts have a hook into the case. Is he Egyptian? Does he live there? His situation is what matters most for deciding jurisdiction, not the wife who's bringing the lawsuit.
And here are the two big rules. Rule number 1 from Article 28 is super simple. If you're suing an Egyptian citizen, you can do it in an Egyptian court. End of story. It doesn't matter if they live in Paris or Tokyo. Their nationality is the anchor. But our husband is Italian. So that brings us to rule number 2, Article 29. This one says that if the defendant is a foreigner, Egyptian courts can still hear the case if that person has a domicile, their permanent legal home, or even just a temporary residence in Egypt.
So, those rules seem to cover most things, right? Nationality or residence. Pretty straightforward. But there is one huge, non-negotiable exception where you just throw those rules out the window, and it has everything to do with something that can't be moved.
And that exception is real estate, plain and simple. An Egyptian court will not touch a case about who owns a piece of land or a house located in another country. And the logic for this is rock solid. First, sovereignty. A piece of land in Italy is Italian territory. Egypt's courts have no business making rulings about it. Second, it's just about practical power. An Egyptian court can't enforce its decision in Italy. Only an Italian court can actually make something happen with Italian property.
Okay, buckle up, because now we're getting into the most mind-bending, but honestly, the coolest part of this whole thing. We figured out the where, which court might hear the case. Now for the what, Which law will it apply? What happens when a court's own rules tell it to use another country's law, but that country's law then points it somewhere else? This legal ricochet has a name, renvoi.
So what in the world is renvoi? It literally means sending back. It's what happens when one country's conflict of laws rules tell a judge to look at another country's law. But here's the twist. Instead of just applying that country's normal divorce law, for example, the judge is told to look at that country's own conflict of laws rules. It's like asking for directions, but instead of getting an address, you're told to use a completely different map.
Let's just walk through this classic example. Step 1. You've got a French court looking at a case involving an English person who lives permanently in Egypt. Step 2. The French rulebook says, use the law of their nationality. Okay, so that points to English law. Step 3, and this is the key, the French court doesn't just grab an English law book. It looks at England's rules for international cases. Step 4, those English rules say, for this kind of thing, use the law of where the person is domiciled, their permanent home. Well, that points right to Egyptian law. So in the end, the French court ends up applying Egyptian law. Wild, right?
Now that example was actually what we call second-degree renvoi. Let's make this simple. Think of first-degree renvoi as a game of legal catch. Law A points to Law B, but Law B's rules point right back to Law A. The case is sent back. Now, second-degree renvoi is more like a relay race. Law A points to Law B, but Law B's rules point onward to a third law, Law C. The case is transmitted. France is famous for accepting this, which is why in our example, the French court was perfectly happy to apply Egyptian law.
All right, that was a lot, I know. So let's hit pause and just nail down the answers to some key questions that always pop up here, using the principles we've just learned. Think of this as your cheat sheet. First up, what law decides if you're old enough to sign a contract or get married? This is called your legal capacity. Well, Article 11 of the Egyptian Civil Code is crystal clear. It's all about your nationality. So if you're an American in Egypt and the age of adulthood in the US is 18, you can sign a binding contract there, even if Egypt's rules are different. Your legal abilities are tied to your passport.
Next question. What's a positive conflict of laws? Well, imagine a situation where two different countries both raise their hands and say, me, I'll take the case. That's a positive conflict. For instance, if an Egyptian citizen signs a contract in France, French courts might say they have jurisdiction because it happened there, while Egyptian courts say they have jurisdiction because of the person's nationality. They both have a legitimate claim, and that creates an overlap.
So, let's pull all of these threads together and come full circle, back to our Egyptian wife and Italian husband. With everything we've learned, how does this complicated system actually give them a clear path forward?
This table lays it out perfectly. First, can the Egyptian court hear the divorce? Yes, it can, as long as the rules for jurisdiction are met. Second, which law will it apply? Well, that's the big it depends. The Egyptian court will now have to consult its own conflict of laws rules to see if it should use Egyptian law, Italian law, or maybe something else entirely. And finally, what about their house back in Italy? That's a hard no. The Egyptian court has zero jurisdiction over that, thanks to the real estate exception. So at the end of the day, what's the big takeaway? Private international law isn't some dusty academic thing. It is the essential, invisible operating system that makes our global world work. It provides a predictable framework for solving messy, emotional, and financially huge problems that pop up when our lives cross borders. Without these rules, every international marriage or business deal would be a complete and total legal gamble. And that leaves us with one last big question to think about. We've seen that some countries, like Egypt, put a lot of weight on your nationality. Others care more about where you actually live. In a world where you can be born in one country, have a passport from a second, and build your life in a third, which connection should matter most? Should the laws of your passport or the laws of your home be the ones that have the final say? That's the evolving puzzle that private international law will have to keep solving.